everyone. It's 10 o'clock or 11 o'clock Eastern, so I wanted to welcome everyone to another episode of AML Gray Matters, a webinar where we explore various issues impacting AML compliance. Today is Thursday, 13th September 2022. My name is Kimberly Smith, and I'm a former compliance officer in MLRO and co-founder of Silo Compliance System, a CDD management and AML reporting tool. I want to welcome our audience from all over the world, and especially to our Silo users. Today, we'll be discussing issues surrounding source of wealth and source of funds in AML compliance. And our guest today is Keisha James from the Cayman Islands. Welcome, Keisha.
Thank you for having me, Kimberly. I'm excited to be here.
Yeah, Keisha is the founder of Synergy AML Services, a new AML consulting firm in the Cayman Islands. She has held legal, compliance, and regulatory positions in both Cayman and the UK. She is a Cayman Islands qualified attorney at law and specialized in the provision of legal services to the investment funds industry. Keisha has held positions with both the Cayman Islands Monetary Authority and the United Kingdom's Financial Conduct Authority, and has served as an anti-money laundering officer on a large number of investment fund structures operated by leading asset managers as well as securities businesses, virtual asset providers, and structured finance vehicles. Keisha also has an in-depth experience of the Cayman Islands regulatory inspection process, having led a team that assisted with a large number of anti-money laundering policy and procedure audits. And Keisha, I don't think I could have found a more qualified and experienced person to join me for this particular topic. However, I'm going to warn you in advance, I may open a can of worms because so many in our audience have expressed extreme frustration with the source of wealth and source of funds requirements and when and how best to apply them. So thank you very much for joining me today and being willing to share with us your thoughts and experiences.
No problem at all.
Yeah, it's great. And as you and I both know, we've kind of been discussing this for the past couple of days, and then there's lots of little issues and pitfalls with source of wealth.
Yes,
source of
definitely.
Yeah. So, and also for our last few broadcasts, we did a drawing for one of our Silo cooler bags. Our winner in our July webinar was Miss Ford in Grand Cayman. So congratulations to her and all of our previous winners. We will draw another name later today from our live audience, and the winner will be notified, named in our next webinar. But before we begin, I do have a little housekeeping. I want to remind our audience this webinar is not legal advice. Today's topic is a little touchy, and I always recommend getting proper legal advice or guidance from your regulators. We are here simply to have an open discussion, and we encourage your questions and comments as the webinar progresses. Certificates of attendance will be auto-generated to live attendees only and sent to you via email 1 hour after the broadcast, so keep an eye out for that email. Check your junk folders. There is one handout today, which is a useful FAQ from 2020 issued by the Wolfsburg Group. So please take a moment to download that. Do remember, however, that your specific regulations may be different from Wolfsburg guidance, and also recording, I think I mentioned that, a recording of this broadcast will be sent out by the end of next week. I'm going to try and get it out by Tuesday. And of course, I am also going to tell people, if you want a copy of these slides, just send me an email. My email will be in that email that goes out. So let's open this can of worms. Keisha, are you ready?
For sure, let's do it.
All right, let's do this. So here are some of the struggles that I've had reported to me, and I'm sure there are others. What has been your experience with source of wealth, source of funds, or your struggles, I should say?
Yeah. So, I mean, this is indeed a great topic. You know, I've worked with many firms over the years, and I've seen firms struggle when trying to establish a customer source of wealth and source of funds. And typically these struggles or challenges stem from regulatory uncertainty as to how far a firm may need to go to show a regulator that they understand the customer source of wealth or source of funds. This is often compounded by, you know, the limited practical guidance out there. Mm-hmm. I've also seen, you know, even general confusion around things like the definition of source of funds and source of wealth, with, you know, the former relating to the actual activity which generated the funds being used for the particular business relationship or the transaction, and the latter being related to activities relating to the overall net worth of the customer or the beneficial owner. So even getting the definition, correct,
But the
there's
two
struggle
correct,
around
yeah.
it.
What's the difference? Yeah. And so for those who might just be listening in this particular slide, we talk about our struggles, again, what Keisha was kind of saying, there's just some expectation, understanding the expectation. Is it supposed to be documentation? Are we supposed to be getting, the past 5 years bank statements? No, is the kind of answer I want to give. Um, but yet we still are expected to provide, like, different reporting on different surveys. And of course, when the inspections come along, there's a few weaknesses that we'll kind of show later on in the slides, where regulators are saying certain files are not having enough information about source of wealth, source of funds. The one that I really kind of noticed is that I said, when I was looking at the different regulations, it seems to be like we're given this risk-based approach. We're allowed to apply a risk-based approach, but then there seems to be this checklist approach during inspections. And then the inspections are kind of saying there's lack of documentation on source of wealth and source of funds. And then there's also, to me, source of wealth and source of funds should really only be required for the higher risk clients. And yet it seems to be expected on all clients and businesses, not just the higher risk. So that's where I think there's a lot of confusion there. And just to show as well, we had over 1,200 people sign up for today's webinar across all of these industries. You can see them listed here. We've got banks, law firms, insurance companies, real estate agents, casinos. We even have some people from citizen investment programs. Tom, if you want to go ahead and list the poll as well, put that poll up. So this is a multi-industry issue, and people are from all over the world. We've got everyone in the Caribbean, we've got Poland, UK, South Africa, and of course the US and UK. So we're all in good company here, being confused by source of wealth, source of funds. But let's go ahead and have this poll. And I think, if I'm correct, the poll is asking specifically just what's been your kind of experience. If you've had an inspection or an audit, and you've gotten some feedback, what's been, and I'm kind of looking at the numbers as they point out here, and yeah, we're close to 50% of you are already saying you've been advised that you need more documentation. Only 13% are showing that they've had no feedback. So let's go ahead and close that up, Tom, and show those results so we can keep this moving. This is I have quite a few slides, and there's a lot to cover here. So I want to kind of keep it going fast. Yeah, 51% are showing that you've been advised you need more documentation. 16% are saying you've been advised you need to request. Sorry, I can't read all the answers. 20% of saying you've been advised you request sufficient information. 13% have had no feedback. 15% are just not applicable. So yeah, so 51% are saying more information needed. So let's go ahead and close that one. So let's just start with the basics. What is the definition of source of funds versus source of wealth? Because as Keisha, as you mentioned, there's confusion as to the definition between the two. Why do you think that is?
Well, I think there's a confusion because just inconsistencies in views out there. So, for example, is your source of funds, where does it originate from? Is it sufficient enough to say it originates from a bank account? But, most regulators do provide guidance, noting that what they're actually looking for is what activity uh, was involved in generating those funds,
Okay.
instead of noting, which we've all probably seen, saying, oh, the source of funds is from my bank account.
Yeah, or it's from a bank in an approved jurisdiction, or not
Right.
from a high risk jurisdiction or things like that. So yes, the source of funds, I think we agree here. It's more than just the account and the financial institution, or the specific account number and where that institution is located. It also involves the activity of how those funds were generated. And I do list some examples here. For instance, proceeds from a sale of a house, or it's an inheritance, or it's gambling winnings, or it's a pension release, or sale of some stocks or dividends, versus source of wealth. And I don't think there's any big confusion about sources of wealth. That's the entire net worth of an individual. And that would include their family inheritance, business ownerships, interest, as well as investments and employment and income. So I don't think there's any confusion there. I think the confusion's always been on the source of funds and the fact that we do need to get just where did that, what activity was behind that particular source of funds. So now, trying to get to the bottom of all the issues related to this topic, I decided to return to the source, the FATF 40 plus recommendations. And for those who are new in compliance, the FATF 40 plus recommendations are the foundation that a country drafts their regulations. And they do provide some examples of enhanced client due diligence measures, and an interpretive note. So, please feel free, read through all these. And here's a little snippet of one. And we talk about, they talk about PEPs and to take reasonable measures to establish a source of wealth when dealing with PEPs. Here's another little snippet of the FATF 40 plus where they talk about enhanced CDD measures, and they say obtain information of the source of funds or source of wealth of the customer. And that emphasis is mine on that customer part because that raises some other issues. The Wilsberg guidance, they also talk about source of wealth. They said, they do say it should not be seen as a documentary exercise. And I think this is where I kind of get to that point where we don't necessarily need to go and ask for, the past 5 years of their bank statements. I'm not a forensic accountant. I don't think anybody else out there is. So even if I did get all that information, it wouldn't necessarily help us. Then I decided to look at the US BSA, that's the Bank Secrecy Act, AML procedures, and they talk about for private banks, customers' wealth, for PEPs, and they use the phrases like should, be considered. And then also when they talk about, based on customer risk profile, I think this is talking about, this is a bank examination manual. And again, they just kind of refer to sources of funds and wealth, the bank may consider obtaining. Again, the word is, that emphasis is mine. They don't use the word should. Then if we go across the pond to the UK, the regs of 2017, section 28, it covers CDD measures, and it's not until ongoing monitoring is mentioned that they use the phrase where necessary, the source of funds should be scrutinized. And then again, later on, it's not until PEPs that are involved that they say adequate measures to establish a source of wealth and source of funds. But then they also say which are involved in the proposed business relationship or transaction. Again, emphasis my own there. But most of us here are not from the UK or the US, so I decided to check some of the smaller jurisdictions. Bermuda gave some guidance for CSPs, that's corporate service providers. And we're all aware corporate structures can be used for layering transactions and hide source of funds that are criminal proceeds. No one's disputing that. Bermuda's guidance here for CSPs seems to have the strongest language, or one of the strongest languages, because it states obtain an understanding and should collect information. But again, it limits it to the wealth and the funds to be used in the business relationship or the transaction. And Cayman, there's some guidance notes, and just so you know, in Cayman, I did a count on the number of times they use source of funds, that phrase, and it is used 33 times, which was the most that I've seen. Even the US didn't use it that often. So the smaller jurisdictions in Cayman especially are definitely, seems to be requiring that information a lot more, but they mention it in like ongoing due diligence. And again, for the corporate legal person, those corporate customers, they talk about, expect turnover and the source of the funds again. Keisha, with your experience in Cayman, anything that you wanted to kind of mention about the Cayman guidance notes and some of their summary findings that they found and released?
Well, and I guess this is a question for the audience as well. So, especially in relation to source of funds, there's a big dilemma on the source of funds declaration that you obtain from clients and whether it
Right.
is enough. You know, it may not be enough for high risk clients, but is a source of funds declaration enough for low and medium risk clients?
Okay.
You know,
And it's interesting that you say that because so you're saying it's kind of pretty standard now that a source of funds declaration is being required on all clients, not just the on higher risk clients.
yeah. Yeah,
Yeah.
I've seen that with firms where it is standard that they do go out and obtain that sort of source of funds declaration for all clients. And you may touch on it, but interestingly enough, I was looking at how the Guernsey regulator looked at this, and they published a thematic review in 2020 on source of funds and source of wealth. And they found that 91% of the firms that they asked, 91% of the firms, regardless of risk rating,
Hmm.
collected source of funds and source of wealth, and 85% collected source of funds on their customers, regardless of their risk rating levels. However, in that case, the feedback to firms was that it was also identified that the level of verification was the same across all levels, and that the regulator noted that this was not an effective approach, and that it had unintended consequences, being that risk setting risk setting the bar too low, where you're collecting this information on your whole client base and
Hmm.
there's insufficient verification being collected for high risk customers in this case, or you're not taking the risk-based approach in dedicating the resources to the areas that need it the most, i.e. the high risk customers.
Okay. Now you mentioned verification. Um, would you define what you would see as verification? To me, that would be getting the documentary evidence, such
That's
as if somebody says it's a sell, it's proceeds from the sale of my house. Well, let me see the contract or something like that, or the valuation of the
that
house.
That's correct. And verification can come in all forms. Like you open source may be a reliable place for verification if it's coming from credible open source.
Hmm.
For PEP, for example, you may want to use an underground investigator to look into the PEP and provide you with a report. I've seen that done in jurisdictions like the UK, where they'll get a third party, get additional verification on PEPs, for example, and that was a
Right.
normal process in getting those reports.
Okay.
So, it can come in all sizes. I mean, it just depends on the risk-based approach and
Okay.
firm is taking.
Okay. So the slides here I was just showing, these are some findings where they're saying where Cayman, SEMA was kind of saying that there needs to be, including where necessary, the customer source of funds needs to be addressed. And also another finding on TC, that's trust company service providers, talking about ongoing monitoring. These were just the AML weaknesses found in 2021. And they're saying, 58% of files reviewed, it had weaknesses in source of funds and source of wealth. So, which kind of matches with our poll that said 51% had said that, they were told that they were not getting enough. So again, our goal here is to try and find out, well, what is enough, what and kind of help us do there. So again, going back to the wording, the actual regulations, and I think this is where the real confusion is, because those the wording of these regulations, they say take adequate measures, take appropriate measures, consider obtaining obtain an understanding. And I think, and of course, and that always seemed to be just in relation to PEPs and the higher risk clients. But it seems to be on the ground. Um, and gosh, it's really different. I mean, if I was working for a casino versus a trust company versus, a bank, it's going to be different across the industries, I think. Um, do you have any guidance or kind of experience on your end, what this looks like across different industries?
Um, Currently, I mean, what it looks like across industries, I think the general consensus is that firms normally get, some form of source of funds declarations. I know for funds industry, it's standard. It's normally standard in the subscription
Mhm.
documentation to ask what the source of funds are from that respect. And for corporate service providers, they're typically getting declarations confirming this. I mean, this information feeds into your risk assessment of the client. So, I've found just generally there is you know, wide exception that parties get confirmation of source of funds and possibly and source of wealth at
Okay.
onboarding of a customer. It's in my view, it's the verification element that may be falling short for firms or where there are issues.
Okay. So it's the verification. Okay. And then yesterday, when we were kind of preparing for this, you brought up this survey. Now, this is from Cayman. They've got a survey being asked of the securities and registered persons. And I've seen other surveys from for other licensed entities as well, and I found it very interesting because they're asking the businesses, and this is a little snippet. They're asking these registered persons, does the entity have any clients where the business or source of funding is not listed in the category above? And of course, and they mentioned in earlier questions. So in question 7.1, they ask, does the entity have any clients in um, where their business or source of funding is with the banking institution or other financial regulated businesses. And I list those here. So they have financial leasing, money lending, legal practitioners, accountants, and fintechs. And then later on, there's another question asking if the entity has any clients where the business slash source of funding is um, with MSBs or VAS, which is virtual asset service providers, high value goods dealers, trust companies, import export industry or shipping and transport. And then later on, another question asked to be those clients to be broken down if they're real estate agents or brokers, precious metals, gambling, adult entertainment, and defense industry. And then, of course, then there's saying in this question, 0.52, does the entity have any clients where the business source of funding is not listed in any of those above categories? And I was kind of thinking about this. I was like, well, that's interesting because there's a few industries missing in these lists, such as healthcare, pharmaceuticals, education, publishing, manufacturing, even. Um, Construction also, for instance, is, with the big construction companies. So what I was trying to figure out is are we needing to make some certain assumptions about these particular industries? Are they supposed to be higher risk industries? Keisha, what's your thought?
And I mean, I think, parties should pay attention to, for Cayman in particular, the national risk assessment and industries that it deems, have maybe a higher risk for money laundering or, higher risk industries. I mean, you could read into some of these, I mean, import, export issues, and shipping and transport, that is a flag for parties to look at for in relation to, for example, proliferation financing risks.
Okay.
But I just think generally, this goes back to the definition of what you need to do for source of funds itself, which is get an understanding of the activity which generated the funds, and did the activity where the funds originate from come from a possibly higher risk industry, because that again should be feeding into your assessment of that customer.
Okay. Fantastic. And just so you know, we will be taking questions at the end. Sorry, it's just this is one of those topics where I'm kind of just banging through this because we really only have about 20 more minutes here. I've got a few slides just showing some different scenarios. So here, this is a slide showing 4 different individuals. 2 are low risk, those are the green. One is what I would call medium risk, and one is higher risk. That's the one in red. Now, in my experience, I would not hesitate to get source of wealth, source of funds documentation for Mr. D, the guy in red. But what I'm kind of hearing, what I'm kind of feeling out what's going on in the world is that really we should have some type of declaration, even for Mr. A, Mr. B, and Mr. C, even though they're kind of deemed lower risk or medium risk. Is that your understanding, even if it's just a simple declaration about their source of funds and source of wealth?
Well, I mean, the general consensus parties are getting that information regardless because it's something
Okay.
that feeds into your assessment of that customer. So, you
Right.
know, yeah.
Okay. As opposed to just getting a copy of a passport and utility bill, which that's what some people are doing. They're just getting that basic identity and address verification documentation, and they're not going into that. But what we're kind of seeing is that, yeah, we do need to be getting that source of wealth, source of funds information on them as well. And then maybe for Mr. D, if that risk assessment from that information makes them higher risk, then get the verification uh, documentation,
Yeah.
correct? Okay.
Well, that is the great debate, right? Parties are doing, firms take a different approach. It's based in their own risk-based approach. So they may be getting verification on Mr. A and Mr. B and C as well.
Okay.
So they may take the approach to get verification of source of funds on all parties versus just
Okay.
Mr. D.
Okay. And then for the behind the corporate entities, again, we all know corporate entities can be used. So similar to kind of what we discussed, same thing, even if they're just shareholders, getting declarations. What you're kind of saying is it's kind of standard these days to get the declarations behind all 4 shareholders of their source of funds. I can understand that. And of course, as you kind of said, it could be based on your risk appetite that maybe even get verification on all of them, not just Mr. D. Is
Yeah.
that correct?
Yeah.
Okay, fantastic. Now, this one here is the one that throws me a curveball, and I think a lot of people. And that is, what if somebody, what if it's the director? It's not the shareholders. Let's say all the shareholders are lower risk. You don't. Yeah, we're not worried about them. But what if it's the director? And you gave a very good answer, or when we were discussing this yesterday in warm up. You want to kind of explain the situation you came across once
Yeah.
when it was a director?
Yeah, so I've actually come across 2 situations where, and we all know, and we've probably seen things in the news and other case studies where sometimes higher risk you know clients, including PEPs, they don't put themselves on structures as the shareholders to effectively mask their ownership in a structure. However, they may still want some control in the structure. And so they're appointed as director. And, until you have enough information on a particular director, you won't necessarily identify that there's a risk. So in that scenario, um, source of funds and source of wealth was obtained on that director. That director in question was a PEP, and it was identified in the structure that the director's source of funds, source of wealth, i.e., the entities that that PEP director worked with or worked for was related to, was related to the source of funds of the shareholders.
Oh, okay. So kind of
That was
more higher up.
digging. So it was after further investigation, it was found that that director did have interest in the entities. They just weren't listed as a shareholder,
As a
but their
shareholder.
funds did.
Okay. Okay. So yeah, so as you were kind of mentioning, it's at times necessary to get source of funds from directors. And the reason why I kind of put this one up is because I definitely had the situation where it was argued, but I'm not putting funds into the company. I'm just being appointed as a director. Why are you requesting my financial information? So there was a little bit of pushback in my experience, and that's the reason why I kind of wanted to raise this one. Um, but yeah, so again, it's kind of going back when you're looking at your policies and procedures to you know, get that kind of nailed down when you're going to request it, and what your regulators are requesting of you. Now, it's also been in my experience, and this slide here, we're talking about fields versus forms. So it's been my experience, like for instance, like there was a director questionnaire or an application for engagement. And these questionnaires, sometimes I have what I call just a field, please provide your information about your source of wealth, or the funds that will be put into this, corporate structure. And I've always seen very limited, brief, explanations, put in. They'll say, oh, it was investments or it's family wealth. Um, and and it's very likely that maybe we need to include more forms to collect that granular detail. Have you seen more forms requiring detailed source of wealth or source of funds information? Are you seeing more of those?
Yes, absolutely. And I think, parties have wised up to this where they're
Hmm.
given examples for example, the ones you listed here. So they're given examples when they're requesting, like actually in the forms, and
Okay.
kind of leading the client to provide the customer to provide more details.
Yeah. And I guess based on that form, what's submitted in that form, then you know what kind of documents you can request to verify.
That's
Because I
correct.
think that's a lot easier for the compliance officer to do than to say, oh well, okay, just to go based on my investments. Well, because sometimes I think where the pushback comes in from the underlying individuals that you're requesting verification documents is that sometimes we don't know what to ask for because we don't have enough granular detail to then say, well, can I see copies of that contract, that real estate contract, or a copy of that will, for instance, or a copy of those gambling earnings, something like that. Um, so yeah, I do think we're going to see more forms being requested of clients and people behind corporate structures. I've also listed here some red flags. So for the high net worth individuals, that significant source of wealth, one of the experiences I've had is not being able to find anything in the public domain. Now, usually high net worth individuals, they give to charities, they're thanked, so, obviously you're having to weigh their privacy versus secrecy. So not everybody wants to be known. But there's usually with high net worth individuals, some information out there in the public domain. Oh, I think you kind of referred to it as open source. Are we kind of talking about the same thing, what you can find on the
Yes.
internet? Yeah. Um, and of course, these PEPs, one of the things that I always like to look for is those large speaking engagements, consulting services, things like that. Again, I'm just trying to always look for, are there any kind of contracts? Who paid those speaking fees? Who paid those for those consulting services? Because that's usually where you're going to find their funds. Because as we all know, PEPs, they earn $100,000, in salary for their work as a public official, but yet they seem to somehow acquire millions. Um, and of course, yeah, the other one I've noted, I came across this situation was somebody had documented and provided us with a contract for their, let's just say, significant executive level salary, yet there was nothing on them about the company website. They weren't listed as, they were supposed to be a board of directors, and yet they were not listed as the board of director on the company website. So stuff like that can kind of be a red flag. And another one that's I've just been made aware of just in the past few weeks is sham litigation. And I don't know how to advise. Have you come across those situations?
I haven't personally come across that situation, but I know it was in the news recently that, this may be a form um, of new form of, fraud coming through. So, yeah.
Yeah, I thought that was very interesting. So there's a link to an article here. You can just probably Google dirty laundry in the courts, or court rulings, things like that. And you might be able to find some others, but I did find that that was very interesting. Um, I'm going to go over to some tips that we decided to provide here. We've got, obviously, check your local regulations. Find out what's. Yes, I think the regulation wording is a bit too, I want to say, too narrow, because they're kind of the regulation wording that I came across seemed to be mostly about PEPs and high risk clients and enhanced due diligence. But as we're kind of finding, what's happening on the ground is that people are being asked to kind of get this information more frequently, to use it as part of your risk assessment, not as the end result of your risk assessment. Do you think, am I phrasing that correctly, you
Yes.
think?
Yeah.
Yeah. So I think that's where the confusion is lies. So source of wealth, source of funds should be part of the risk assessment in reality, and not just as a result of the risk assessment. Um, I've also come across situations where people are de-risking clients simply because they don't want to get source of wealth, source of funds. Please don't do that. Um, Also, the reviewing your ongoing monitoring procedures. And this is where I do find that there's usually gaps. It's almost as if by the time you get to when your people are drafting their manuals, by the time they get to the enhanced due diligence procedures, they've worn out. And so I'd say take a moment to review your enhanced due diligence requirements and make sure you're documenting about getting that source of funds review in there, and be specific with your documentation requests with your clients. Any verbal discussions with clients, maybe you haven't necessarily, because remember, some of the wording in these regulations, they talk about getting an understanding. So even if you're just having a verbal discussion, or there's email threads that kind of go on over several days, or sporadically, make sure you well document your understanding, whether it's as a file note or some kind of call memorandum with date, time, who was there, who had that discussion. And the other thing I would say too is just trust your instincts. Don't hesitate, especially for junior compliance people and support staff. Don't hesitate to ask for a lawyer or an accountant of the client to kind of submit a letter. This is a good way too, if your red flags are going off. And Keisha and I were talking about this yesterday, that sometimes I've had the experience where sometimes you're like, I couldn't put my finger on it, why
Yeah.
somebody was calling up and asking because they wanted to set up a Cayman company, and it just didn't make any real legal sense to me. And so I'd say, okay, well, I need a lawyer, an accountant, describing why, talk about your wealth and your funds and how it's going to put in there. And they go, yeah, 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 I'll get that to you. And then we never hear from them again. So it's a good way
Yeah.
to, I don't know
Yeah.
if
I had
you
a
find these ways.
situation where a construction Eastern European company just wanted to set up a construction company in the Cayman Islands.
Mhm.
Well, not a company that their funds would come from a construction company in Eastern Europe. And there was no rationale um, for setting up
It's
a
not a joint
company.
venture. It's not for,
It's not,
lots of different people from different companies, different countries, no tax reasons.
no tax reasons, no
Yeah,
nothing. They just want a company in the Cayman Islands, and
yeah,
the fund, they would want to open a bank account for. And so, yes,
yeah, yeah. So, interesting. Yeah, no, those are the ones where I'll ask for, somebody, some onshore lawyer or an accountant, to confirm the structure or confirm the reasoning, or why this is particularly relevant to them. And yeah, I never hear from them again. So that's a good way to kind of protect yourself. Another one is if you're not sure and you want a second person, I would say you feel free to get a second person to sign off, just for uh, just to get a second opinion. That's what I would always do too. All right, we're going to move into Q&A. So let me get my mouse here to work so I can move on to the next one. Next slide. There we go. And let's go ahead and see what kind of questions we've got here. So we've got quite a few. Let me see. Okay, so we have Juliana. She's asking what exact elements must be identified in source of wealth and source of funds documents. Now she's asking about documents. Is it enough to identify name, surname of the client in the document, amount and type of funds, such as salary and dividends? I would think so. I think that's a starting point, kind of what we were talking about.
Yes. So in that example, identifying salary, so it's, salary from, getting a little bit more granular information. So it's from
Okay.
salary from my employment with Synergy AML, for
Okay.
example. So the compliance first personnel will need the additional information, because then they can do any other checks in that. So salary alone would not work. You
Okay.
need a little bit more, so you can check that if you need to.
And salary is usually quite easy because it's
Yes,
a yeah, you can get that from let's sort of a pay stub, for instance.
yes,
Yeah.
yes,
Now, somebody's actually disagreeing, Steve, and I believe Steve's based in the UK. He says more documentation validation is not strictly true. He says the questions we are asked is, have you been able to independently verify the information you have been given? So that's quite a good point for those who are coming in from different jurisdictions, and I think that's just kind of down to a regulatory uh, expectation what your inspectors are wanting to see as verification. So that's very interesting. Thank you, Steve, for that comment. Um, Hugh in the so he's in Cayman. He says, as a CSP, that's a corporate service provider in Cayman, are we required to collect source of wealth rather than source of funds information regarding directors and shareholders? Now, this came in earlier on in our discussion, so this is probably a little bit before we got to those slides regarding directors and shareholders. Now, and what you and I are kind of leaning towards, again, if I maybe just need to restate this, um, is that, yeah, we need to kind of start assessing that source of wealth to be part of the risk assessment, correct?
yeah, yeah. Well, source
Yeah,
of funds,
source of funds.
as part
Yeah,
of it. And
yeah,
there are different approaches, in this scenario, in whether you do collect that information at directors. So and that question is kind of, the big debate here. Should it be
hmm,
collected on directors for higher risk, um, directors? Definitely. For PEPs, for example, there's no differentiation on whether or not, on whether they're a director or not. From a Cayman perspective, the guidance clearly says that you need to collect source of funds, source of wealth. So it doesn't matter what position they hold in a structure, in that respect, for example.
okay. Yeah, he's saying the recent SEMA AML questionnaire appears to require us to know if a director is a high net worth individual or ultra high net worth individual. And I know there's breakdowns in net worth. Now, and of
Yes,
course, but if I, Kimberly Smith, was appointed as a director, you wouldn't know if I was an ultra high net worth individual. I'm not,
that's
by the
correct.
way, but
Yes.
but you wouldn't know if I was unless you had some information about my source of wealth.
Yes, and exactly. And so, yes, I've seen the survey, and that question is definitely being asked of directors, whether any controllers have, or high net worth. And there's no way you would know unless you're collecting the source of funds or a source of
Yeah.
wealth on them.
So I guess in your director questionnaire, when you're appointing somebody, and you're in, because most corporate service providers have a director questionnaire, you would have to ask that question: is your net worth above a certain level? Um, and then if yes, they're going to have to somehow independently verify the words Steve's been asking, that information on their wealth. Is that how you would understand that too?
Yeah,
find a way
well,
to.
I don't think it is the expectation that every single party in the transaction is independently in the structure is independently verified. It's the risk-based approach again, um, clicking in there, but
Okay.
whether
So at
you
least
collect
know,
the
yeah,
yeah.
just know if
So
they're a high net worth individual.
yeah,
Okay. All right. Another question. What would you equate to reasonably identify source of wealth? If we speak to inheritance or accumulated wealth, how far do you go back? Do you get a client to sign a declaration and provide account statements from when the company was first incorporated? If it's a generational company established 3 or 4 generations prior, what would be the most recommended approach here, including the verification? I My first thought, and this is John who's asking that. Sorry, I'm not familiar with John. I don't know where he's calling in from, but my first thought is these companies that have been running for generations usually have, a team of lawyers or an accountants. That's, I mean, is any
yeah,
kind of just letter from them
yeah.
sufficient, you think?
Yeah, and I mean, information from a professional advisor or a solicitor or accountant or tax advisor is
Mhm.
also a form of verification.
Yeah.
So, well,
Well,
and
again,
so
going back, we're not forensic accountants. So if I,
yeah,
asking for, the past 3 years or 30 years of, you know, financial statements is not going to help me at all assess if there's any fraud going wrong. But a letter from their lawyer, uh, you know, would put me more at ease. Um, Okay, so Hubert, he goes, obviously, this is a big challenge for a casino where patrons are there for entertainment purposes and find it odd to have to provide documents. And I completely agree. When I noticed that we have a handful of people from casinos, and sorry, I have no casino background other than losing money myself. So
yeah,
I really can't help you guys as far as, I mean, I don't go to a casino and buy $500 worth of chips, I guess, or tokens, I guess is what they use here. And have never had anybody say, okay, now we need a copy of your, pay stub. It's just I just don't think
yeah,
it's going to happen.
no,
Uh, I would think, to me, in the casino industry, that might be for your big players, anybody who's cashing in, 10 grand or more. But even then, I mean, I really don't know what you would do when you've got somebody trying to buy chips, sitting there at the window and you're asking for. The only thing I could say is that's where you're gonna have to go back to those regulators and find out what they're expecting, because I don't have
yeah.
any feedback for you. Um, yeah, Kurt, he says, good point. These regs are not prescriptive, and it becomes problematic internally in organizations, especially between departments. Do you have any particular way of how this should be applied in business? And again, I don't know what business Kurt's in specifically. Um, so yeah, this is where Kurt, I would recommend you just go to straight on to somebody local, some legal advice locally, or a consultant locally. Um, Kenneth, he says, for securities and registered persons who perform fund management, do you believe that they are carrying out transactions on behalf of the fund, or are these transactions their own obligations as FSPs? Sorry, does that make sense to you, Keisha?
It does. I'm not sure it's a source of funds or source of wealth question here, and more. I think this is one where you need to speak to your legal advisor and how it's organized. So, how your structure is organized, how your agreements are organized
Okay.
in relation to, for example, carrying out transactions on behalf of your funds. There's so many variables there. Are you using, you know, the fund's money to trade directly as the securities registered person manager itself, or is that being done by another third party? But for example,
Okay.
an onshore party, for example. So there's so many variables in that question. So I would just check with your legal advisor on that.
Okay. All right, yeah. And Karen, she mentions, and she's right here. She goes, we need to separate source of funds and source of wealth. They are two different things, and source of wealth is not normally needed. Again, depending on the type of business you're doing, and I think she's very right. I think we do need to state that very clearly.
Yes.
And maybe that source of wealth is as we've kind of mentioned, is just the high net worth individuals, the PEPs, as well.
And that also
Question.
depends on the jurisdictional your own jurisdictional requirements as well.
Yeah, yeah.
Your regulators say in their guidance and what the regulations actually say for your particular jurisdiction.
Yeah,
Yeah,
she's in Cayman. Yeah, so
yeah,
that's very right. Gareth writes, question for later. When onboarding a corporate entity, and particularly a smallish entity, should all directors be screened against lists for PEP's adverse media? Yes, I think so. That's
yeah.
my first my first response. Absolutely, absolutely.
And don't forget
Um,
sanctions.
yeah, yeah, absolutely. Don't forget, say, yeah, you've got to be screening. If you're screening against sanctions, and your whatever screening provider you're using, sometimes they do break it down by PEP's adverse media versus sanctions. But absolutely screen all your directors. You don't know what's hiding behind the
Yeah.
things.
And
Um,
plus, that's a useful tool for identifying your initial risk. If you
yes,
haven't screened, you're getting all this information, their names, etc., but you don't know any risks you're being exposed to yet until you've done that screening.
yeah. Absolutely. Yeah, I won't even finish. He says, or do we only screen those directors that we deal with directly? No, no, I screen every single one of them. Um, yeah, so some of these are kind of saying, yep, issue resolved. Thank you. Okay. Another Karen, different Karen, also in Cayman. She goes, this is a suggestion to ask for source of funds and source of wealth for all shareholders, regardless of shareholding threshold or where there is a high risk element. And again, going back to the other Karen's comment, separate source of funds and source of wealth. Um, Now she says is a suggestion to ask for source of funds and source of wealth for all shareholders, regardless of shareholding threshold or where there is a high risk element. So in Cayman, it's what we got to do KYC on 10% plus shareholders, correct?
Yeah,
Is that still the case? Yeah. So,
yeah.
and she's saying, so what if somebody only has 5%? You're not required to get AML, due diligence, but would you still, if they only hold 5%?
Well,
Or
it
would it
depends,
maybe
right?
depend on the amount of that 5%?
Well, it depends. You could have identified some risk factor. That 5% holder could be politically exposed.
Okay. Okay. So we don't
And
just
then,
flat out ignore the 5% shareholders. We still want to
oddly
have
enough,
a reputational risk.
yeah, oddly enough, where, most of the risk identified triggering internal suspicious activity investigations that I've encountered related to less than 10% shareholders
Mhm.
from my, experience over the years.
Yeah.
So,
And we have to remember they're as smart as we are, sometimes if not
yes,
smarter. They know that, if 10% or less is what's looked, 10% or more is what's looked at more closely. So they know how to structure these deals to not get put under the magnifying glass. Um, so yeah, so again, and going back to the other Karens, you separate source of funds and source of wealth. I wouldn't require source of wealth except for as we kind of mentioned the PEPs and the ultra high net worth individuals. Um, yeah, somebody's asking about PEP associates. That's just your families. That's a kind of whole different webinar um, topic. So I'll skip over that one. Okay, here's a question from Pierre. What instance have you seen provenance of assets used as source of wealth and source of funds? Or is you're kind of, oh, sorry, I lost that. Um, what is that kind of what instance have you seen provenance of assets used as source of wealth, as source of funds? Does that make sense to you, or am I
uh,
being
I'm,
dense?
I'm not, I'm not really sure if Pierre can provide some clarification of what he's
Okay.
requesting.
Yeah. Sorry, Pierre, if you're still with us, if you don't mind kind of giving us more guidance with that questions. Um, said, okay, Melissa, she asked, and should bank statements be requested for all clients upon or onboarding despite the risk rating? I would say no. I think that's going over, again,
Yeah,
if you're just if you're just ticking boxes, then we're not really assessing. And I think that's a bit overkill. I mean, if I was told to submit my bank statements every single time I wanted to open a bank account, well, or incorporate a company or something, I think that's just a bit overkill. I do a true risk assessment to then verify. And I would give,
yeah,
Melissa, I would kind of encourage you to kind of look at and work with your local consultant, because I know I think you're in Turks and Caicos. Um, work with a local consultant to come up with some type of form that can then help you identify where your risks are and what you then need to validate.
yeah.
Um,
Again, as Kimberly said, the whole goal here is, is to dedicate the most resources
yeah,
to the risk that you've
yeah,
identified instead of
yeah.
that tick box.
Mm, and as I like to say, my brain is my brain cells are a limited resource. So, if I'm having to review bank statements on every single client, director, and shareholder of a corporate entity, it's I'm going to miss something. So yeah, so again, we're not forensic accountants. So even if I have 10 years worth of bank statements, it's not going to help me assess the risk here. Um, Okay. How would source of wealth be established for someone having some worth due to virtual assets? So I want to make a joke here and say, does anybody investing in Bitcoin still have any wealth left?
I,
But, um,
I do not want to look at my account right now.
I know. Yeah, I'm sorry. It's that might be a moot point at this point. Um, Oh gosh. I mean, I do know, like I said, I've played around with Bitcoin just so I can understand it, and invested in Bitcoin. There are statements you can get.
Yes.
You can see somebody, you can ask for their statement from last year when it was 60,000 a coin, and then when they bought it and stuff like that. So there are some statements you can get, especially if they like made a killing. Ask for when they first bought into it back in 2015 when it was $500 a coin, and then show their sale of when it was later on. I mean, that you can get statements. It's not all just thin air out there. There's a bit more out there. Um, do we need to have more information on family property oh, that's a good one for source of wealth. Because that's a good one when I would think, and to me, that family inheritance from people from very wealthy families where everything's like in a trust, because that's usually going to be the situation. It's all going to be in a trust if they've done their any kind of asset planning correctly. And if and if they've got assets to the benefits of that trust, I would be asking for trust documentation. Is that kind of your understanding?
Yeah, I normally see that being requested. Yeah.
Yeah. Yeah. So start with the trust documentation, and then he says, or only asset valuation. Get the trust documentation showing that that person's a beneficiary of the trust, and go ahead and ask for asset valuation. What's that worth? What's the shareholdings worth? All right, Renee, and we're closing up here soon. We've got like 2 more minutes left. So we got, what public sources of information for high net worth persons are acceptable? Public sources, that's anything on the internet. Do you have any other resources that you use?
Well, it should be. I just want to, when you're using open source, just ensure that it's credible and it's not like a self-updating tool like Wikipedia. Anyone can update Wikipedia. So just make sure that the open source is credible,
Hmm.
open source.
Okay. Okay. Steve has another comment. He says risk-based approach for ID and verification. Are they contributing funds to, or will they benefit from the structure? Then a source of wealth is required. And he's an Isle of Man. He wanted me to clarify that. So thanks, Steve. I value all of Steve's comments. He's usually I think he's very experienced. Okay, so risk-based approach for ID and verification. He's saying we're having to ask, are they contributing funds to the structure, or will they benefit from the structure? and then which
Right.
then source of wealth is required. Oh, that's kind of interesting. So he's kind of clarifying that. That's very interesting. Okay. Um, Kenneth, he says that the company's manager, SEMA survey asked questions on business management activities. They ask whether AML services are provided. Do you believe that SEMA see AML services as a regulated activity requiring SEMA management? Oh, okay, that's a whole different ballgame, Kenneth. I'm going to
Yeah.
skip over that one. I'm going to, yeah, sorry. Um, Okay, yeah, we're running. It's top of the hour now, so we are going to move on. Keisha, a huge thank you for joining us today, and I apologize. We never get to all the questions. I'll try and save more and more time for questions at the end of these broadcasts. But again, I want to remind our audience that our viewpoints are our own. We do encourage you to seek local consultants or legal counsel to help you navigate your specific regulations and group policies. I know group policies is a big deal right now because everybody's doing their gap analysis. Um, Keisha, anything to tell you want to tell us about Synergy? You're new. Welcome to the business world. Wishing you the best. There is your website uh, for anybody who wants to look at you. You're based in Cayman. You have training tools. You're providing services. Any particular service? Any industries that's your favorite to work with?
Uh, I take no, I don't look at favorites. I'm genuinely out here to help the Cayman financial service industry grow. I just want to say thank you for having me, Kimberly. Synergy is a full service boutique compliance firm offering bespoke AML and regulatory compliance consulting, including, as you mentioned, training, outsourced AML officer, policy review, etc. Um, yeah, and that's about it.
Right.
Contact me if you want to informal
And
chat.
you're not just AML too. You were talking yesterday about corporate governance as
Yeah,
well.
so I'll also help you look at, your other conduct rules that you'll need to look at from a regulatory perspective and help with your
Okay.
policies, etc.
Okay. So please welcome everyone to Keisha to the consulting world, and best of luck to you. I'm sure we'll be in touch. I'm sure. Our next webinar is 9th November 2022, so it's really just in a couple weeks, 3 weeks I think, and we'll be discussing enhanced due diligence with our guest. I will be sending up a following email with today's recording. So you're going to get certificates in about an hour for those who attended live. And then next week, probably Tuesday, Wednesday, we'll have this recording kind of, edited and stuff, and we'll send that link. And of course, if anybody wants to have a copy of the slides, please send me an email. And it'll be in today's follow-up email in about an hour. My email address. So yeah, please do send me a quick email, and I will just drop those slides to you because they are too large to send out. Please continue to follow us, follow Silo and LinkedIn, and we encourage you to share your thoughts with us. Oh, and we had one more poll. Tom, you want to release that poll real quick? We always like to kind of get some feedback. How did we do today? Are we kind of helping you out with these discussions? So today's is like, how did you find today's session helpful at all? And obviously, I give you the option to say nope, you're more confused than ever because sometimes that does happen. But yeah, I want to again thank you, Keisha, for sharing your experience and those that have put in your questions as well. And I will be doing the drawing here in a few hours for the cooler bags. I know people have enjoyed receiving those. Kind of unexpected fun there. All right, so let's go ahead and close this up. I'm showing 0% have said that they're more confused than ever. Keisha, we did good. Excellent.
No, thank you.
Um, 15% has said somewhat. They've gotten a little. They're gonna have to do some more research. So hopefully you will get your local consultants. 32% have said yes. I know now they can do more, and 52% fantastic. You say you feel more confident about your current procedures. So that is fantastic. Thank you. I'm glad we could help for those who are put you more at ease. Great. Again, those who are looking for different technical solutions, here's just a list of people you can contact, whether it's your AML and CDD, data privacy, or any cybersecurity tools that you're looking for. Feel free to reach out to us and request more information and demos. So again, and that's it for today's broadcast. Thank you again, Keisha, for sharing your experience with us today. To our audience, too, thank you for joining us. I know your time is very valuable, and thank you for spending some of that time with us today. I hope you found today's broadcast informative, and it can help you strengthen your AML program and keep you and your organization safe from the current from the current landscape that's going on. And in the meantime, if anyone is looking at compliance systems, I encourage you stay on to watch this little short 2-minute video to learn more about Silo. It's an AML regulatory management system. We help our users efficiently manage all of their client due diligence and reduce the risk. I want to thank our Silo users who are out there and who join us for these webinars too. I appreciate your time with us. Until next time, this is Kimberly and Keisha signing off.
Anti-money laundering compliance and customer and vendor onboarding involves multiple processes that must be done correctly and by the right people in the most efficient way. The tasks include gathering customer and vendor ID and verification documents, screening against sanctions and politically exposed persons lists, analyzing any reputational risk, periodic monitoring to assess any changes and updating due diligence, and staff training on money laundering, terrorist financing, bribery and corruption awareness and risks, as well as keeping them up to date on your policies and procedures and new regulatory requirements. In addition to the onboarding processes being strictly followed and documented, management must have access to critical compliance metrics and information to steer the company through regulatory waters and mitigate customer and other risks. With Silo Compliance System, these obligations become much more efficient. With Silo, your staff can enter the customer's information and upload due diligence documents and any other documents that you require. Key information entered about your customer automatically calculates a risk score, a calculation using a risk-based approach determined by you at initial implementation of Silo. In addition, if you have screening enabled, when the customer's name is first entered into Silo, the name is checked against sanctions, politically exposed persons lists, and adverse media. You'll see results of screening immediately and can review any potential hits right away. And with screening enabled, your customers and vendors are continuously monitored for any sanctions advisories, helping you get ahead of any potential reputational risks. No company is too small to benefit from using Silo. Even if your onboarding processes seem under control today, if one key staff member becomes unavailable or there is any increase in your customer portfolio, compliance with strict onboarding and review processes can quickly overwhelm a small company and put you at risk. Plus, implementing Silo can reduce the need to hire additional staff to manage compliance obligations and reduce your risk of non-compliance regulatory penalties and continued inspections. No one goes through an inspection or audit with great ease, but several users have reported that their inspections went more smoothly and with Silo they had improved outcomes. Reach out to us today to schedule a demo of Silo.